Case 66. Alejandre versus Republic of Cuba. This video may contain disturbing content. We find ourselves again in the U.S. District Courts, this time for the South District of Florida. Facts. The government of Cuba, on February 24, 1996, in outrageous contempt for international law and basic human rights, murdered 4 human beings in international airspace over the Florida Straits. The victims were brothers to the rescue pilots, flying 2 civilian unarmed planes on a routine humanitarian mission, searching for rafters in the waters between Cuba and the Florida Keys. As the civilian planes flew over international waters, a Russian-built MiG-29 of the Cuban Air Force, without warning, reason, or provocation, blasted the defenseless planes out of the sky with sophisticated air-to-air missiles in 2 separate attacks. The pilots and their aircraft disintegrated in the mid-air explosions following the impact of the missiles. The destruction was so complete that the 4 bodies were never recovered. The personal representatives of 3 of the deceased instituted this action against the Republic of Cuba and the Cuban Air Force to recover monetary damages for the killings. One of the victims was not a U.S. citizen, and his family therefore could not join in the suit. This is the first lawsuit to rely on recent legislative enactments that strip foreign states of immunity for certain acts of terrorism. Neither Cuba nor the Cuban Air Force has defended this suit, asserting through a diplomatic note that this court has no jurisdiction over Cuba or its political subdivisions. A default was thus entered against both defendants in April 1997, pursuant to Rule 55 of the Federal Rules of Civil Procedure. Because this is a lawsuit against the foreign state, however, the court may not enter judgment by default. Rather, the claimants must establish their claim or right to relief by evidence that is satisfactory to the court. These 3 consolidated cases proceeded to trial on November 13, 14, and 20, 1997 on the issues of liability and damages. Because the court finds that neither Cuba nor the Cuban Air Force is immune from suit for the killings, and because the facts amply prove both defendants' liability and plaintiffs' damages, the court will enter judgment against defendants. What's the issue? The issues were liability and damages. Holding. The court held that the Cuban Air Force was liable for both compensatory and punitive damages. Under the theory of respondeat superior, Cuba is liable for the same amount of damages as its agent, except for punitive damages, which the FSIA prohibits against foreign states. Estate of Armando Alejandre, loss of future income earning potential $1.3 million, loss of household services $206,000. To Marlene Alejandre, the wife, mental pain and suffering $7.5 million, loss of companionship and protection $500,000. Marlene Victoria Alejandre, the daughter, mental pain and suffering $7.5 million. Loss of parental companionship and guidance, $500,000, totaling $17.5 million. Estate of Carlos Alberto Costa, loss of future income earning potential, $5.1 million. Osvaldo Costa, his father, mental pain and suffering, $5 million. Loss of society and companionship, $500,000. Mirta Costa, the mother, mental pain and suffering, $5 million. Loss of society and companionship, $500,000, totaling $16.1 million. Estate of Mario M. de la Peña, loss of future income earning potential, $5.2 million. Mario de la Peña, father, mental pain and suffering, $5 million. Loss of society and companionship, $500,000. Miriam de la Peña, mother, mental pain and suffering, $5 million. Loss of society and companionship, $500,000, totaling $16.2 million. Judgment is hereby entered on behalf of plaintiffs and against defendants, the Republic of Cuba, and the Cuban Air Force for a total compensatory damages of $49.9 million. Further judgment is hereby entered as punitive damages, the sum of $137.7 million. Under the Foreign Sovereign Immunities Act of 1976, the federal court lacks subject matter jurisdiction to hear a claim against the foreign state unless that claim falls within one of the FSIA's enumerated exceptions. For example, if a foreign state commits a tortious act or engages in commercial activities in the U.S., it may fall into one of the FSIA's exceptions and be stripped of immunity from suit in U.S. courts. Congress crafted an additional narrow exception to foreign sovereign immunity through the Anti-Terrorism and Effective Death Penalty Act of 1996, which amended FSIA to allow suits in U.S. courts against the foreign state that engages in acts of terrorism under certain specified circumstances. As a result, the FSIA now provides that a foreign state shall not be immune from the jurisdiction of U.S. courts in any case in which money damages are sought against the foreign state for personal injury or death that was caused by an act of torture, extrajudicial killing, aircraft sabotage, hostage-taking, or the provision of material support or resources for such an act, if such act or provision of material support is engaged in by an official, employee, or agent of such foreign state while acting within the scope of his or her office, employment, or agency. Section 1605 is a requirement that the foreign state have been designated as a state sponsor of terrorism had been satisfied in the Alejandre case. Cuba was one of only 7 states so designated at the time, pursuant to the authority of the Export Administration Act of 1979. The Civil Liability Act creates a cause of action against states of a foreign state that acts under the conditions specified in FSIA Section 1605. Therefore, it serves as an enforcement provision for acts described in 1605. If plaintiffs prove an agent's liability under this act, the foreign state employing the agent would also incur liability under the theory of respondeat superior. According to the Alejandre court, plaintiffs presented compelling evidence that all the relevant statutory requirements have been met. Thus, the court found that both the Cuban Air Force and Cuba were liable for the murders of Alejandre, Costa, and De La Peña.